Today's courtroom drama is nothing short of explosive. A man with a criminal history spanning decades from theft and assault to drug distribution is now back in front of the judge after wielding 2 tomahawks. During a confrontation with his the state has a plea bargain on the table, but will the judge accept it? And more importantly, should she? The courtroom is tense as we dive into the life of Glenn Lorenzo White, a 62-year-old man who claims he's changed. But the judge isn't buying it. With accusations of family violence, a deadly weapon enhancement, and a deeply tragic backstory involving lost parental rights and drug abuse, this case is a collision of poor choices and painful consequences. But here's the real kicker. Can a man who's failed probation, violated parole, and lost everything still be given one final shot? Drop your thoughts in the comments. Should repeat offenders ever get a second chance? Or is enough truly enough? Buckle up, because this courtroom session is about to get real.
All right, the court is calling 2025 CR 002709, State versus Glenn Lorenzo White. Could I have parties announced, please?
Rick Pena for the state of Texas.
Bob Romack for Glenn White.
And are you Mr. White?
Yes, ma'am.
All right, you entered a plea of no contest on May 27th. According to your plea bargain agreement, punishment is to be assessed at a cap of 6 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon. This is to run concurrent with 2025 CC 005111, and there's an affirmative finding of family violence. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, ma'am.
Any objections? State?
Not from the state.
No
Defense.
objection.
All right. Any witnesses from either side?
No.
At this point in the hearing, we learn that no witnesses will be called, a notable decision that shifts the weight of the case entirely onto the PSI report and the judge's interpretation. But notice the defense strategy here. White's attorney leans heavily on rehabilitation, highlighting outpatient treatment and weekly drug testing. This is classic mitigation language designed to humanize the defendant and frame him as someone who's finally ready to change. But viewers, think about this. Can someone truly change just because they've done time? Or does genuine transformation require more than promises and a rehab schedule? The emotional pitch is set. Now the judge is about to dig into the ugly truths behind the so-called mistake, and, trust me, this is where things get dark.
Any witnesses?
None from the state.
All right, then, state. But Lucy, I believe you may be opposed. Just one moment.
I was silent, Your Honor.
All right, you're solid. All right, you may be excused.
Thank you, Your Honor.
All right, counsel, I'll hear your argument.
Judge, Mr. White's had some issues in the past. He said it's different this time. He spent time in jail. It's helped him develop a new outlook. He told me he's going to follow your instructions. If you give him probation, he'll never be back here again. We like the recommendations, the probation, the outpatient treatment, weekly drug testing. He's had a drug problem. He needs to address that. Also, the 180-day jail sanction is a good idea. We're in agreement with all of that.
All right, so, Mr. White, is there anything you want to say?
Yes, ma'am.
You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record, please.
My name is Glenn Lorenzo White.
All right, what did you want to say?
I was saying that I made a mistake in my life when I lost control.
All right, so here's the thing. Are these mistakes or are these choices?
No, it was really a mistake.
Why do you say it's a mistake?
Because I don't know, I just lost it at that moment.
Well, no.
I got really angry and stuff.
No, here's the thing. You picked up a hatchet, right?
It was tomahawk.
Okay, you picked up 2 tomahawks. Did you think it was something else? Or did you know it was a tomahawk?
No, it was tomahawk. I just grabbed them and I wasn't thinking.
Here it is, the turning point of the entire hearing. The judge directly challenges White's claim that this was simply a mistake. But how do you call grabbing 2 tomahawks and approaching your partner while yelling threats asleep? This isn't just poor judgment, it's a dangerous escalation, and the judge isn't letting him spin the narrative. She peels back the layers, from drug use and terminated parental rights to the choice of still being with someone labeled as equally unstable. This moment raises a serious question for viewers. At what point is a mistake no longer a mistake but a pattern of violence? And should emotional pleas outweigh actual risk when someone's freedom is on the line? Leave your thoughts below. Do you believe White really lost control, or is this just another case of refusing to take full accountability?
All right, so you grab 2 tomahawks, and according to this, it's with this Monique Gant,
Yeah.
someone that you've used drugs with. I don't know why you all are still together, because I read the PSI report, and you have 2 children, younger children. You don't even know where they are because you were using drugs, she was using drugs. You didn't get your life together with CPS, and your rights ended up being terminated, and you're still with this person. So according to this, it says, because I want you to tell me where the mistake is. Victim stated that suspect, that's you, arrived at the location to charge his car battery. Suspect saw victim's car and went inside the house to take groceries that the victim bought. Suspect put 2 hatchets on victim's car. Suspect then grabbed a pole that was on the ground and tore through victim's taped up window and attempted to grab things from her vehicle. Suspect then grabbed the 2 hatchets and was swinging them around, approaching victim, coming within 5 feet of victim. Victim stated that suspect said, "I'm going to cut this bee," and noticed witness standing behind her. Victim stated that suspect walked to the neighbor's house and dropped off the 2 hatchets at the neighbor's house.
That's not true. I went to my mom's house. That was my mom's house. And
So why would you try to take groceries from the vehicle?
I didn't take no groceries from no vehicle.
Well, I mean, she said you cut through her window. I'm assuming the window
Yeah,
was.
no, I picked up the little pipe thing and it had plastic on the window and everything. I tore it open.
Why?
I was intoxicated too, Charlie.
All right. Here's the thing, Mr. White. I don't think you'll be a good candidate for probation. And let me just tell you why. You've been on probation before. Then you have a theft case that you were convicted of. Then you have a criminal mischief that you were convicted of. Then you have an assault case that you were convicted of. This started in the 80s. And then you have another criminal mischief that you were convicted of. Then you have another assault case, they say dismissed for insufficient evidence. It's probably dismissed because the complainant didn't want to go forward with it. Then you had a possession of marijuana, and I realized, it's marijuana, but you were placed on probation for that, and your probation was revoked. Then you had another assault, and now we're in the 2010s. You had another assault, and you were given probation, and your probation was revoked.
This section is a masterclass in judicial analysis. The judge lists offense after offense, from assaults and thefts to drug charges and bond violations, painting a timeline that spans from the 1980s to now. And what's key here is how each failed probation or revoked parole undercuts the defense's plea. Notice how the judge isn't swayed by tears or aging pleas. Instead, she focuses on the consistent inability to follow the law when offered leniency in the past. This isn't just about one bad day with a tomahawk. It's about a lifetime of bad decisions. And viewers, do you think age should ever be a mitigating factor? White says he's near the end of his life and wants to see his elderly mother. But the judge asks the brutal but necessary question. If you cared about your mother's health, why commit a felony knowing the consequences? Let us know, should compassion play a bigger role in sentencing when time is running out? Or does public safety always come first?
Then now you have a violation of bond or protective order, which I'm assuming is related somehow to this incident. Then you had an aggravated robbery case that was rejected. I'm not even considering that because it's rejected. I don't know why it was rejected. Then you had dealing cocaine. You were sentenced to state jail facility. Then you had another dealing cocaine and you were sentenced to prison. Then you had a burglary with intent to commit theft by force, and you received 15 years for that. And then you had another manufacturing delivering. You did time for that. Then you had an aggravated robbery. It was dismissed for missing witness, injury to the elderly, dismissed, missing witness. And now you're here before me. How old are you?
I'm going to be 62 years old.
All right. So I don't think you're a good candidate for probation.
Can I say something?
Sure.
See, I changed my life. My mom got sick now. I'm old too. And I don't know if I had that much time left in my life. But I really want to see my mom. She's in her 80s. If I go away, she gonna pass away. That's all I have in my life is my mom.
All right, so here's my question for you. And I'm not trying to be cruel, but you knew about your mom. Why would you do this, knowing about your mom?
Well, my mom just got sick recently since I've been locked up. This shit started since I got locked up. She's been in the hospital in and out about 4 or 5 times. She had a minor heart attack.
Yeah.
I didn't think it was going to be like this.
Well, I mean, these are things we need to consider, right?
Yes, ma'am.
All right, this is what the court is going to do. The court is finding you guilty. There's an affirmative finding of deadly weapon, affirmative finding of family violence. The court will sentence you to 5 years in the prison, give you credit for any time served. This is to run concurrent with 2025 CC 005111. There's an affirmative finding of family violence, and there's to be no contact with Monique Gant, G-A-N-T, and the court will recommend the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence and also a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. All right, we can go off the record. Here's the thing, Mr. White. Your history doesn't look good, right? And sometimes I look at that, right? And I have to look at that because I have to consider everything. And so I'm looking at your history, and your offense is escalated. And then you have different issues where you are placed on probation, your probation gets revoked. You're given parole, you don't do well on parole. And I will tell you, I've done parole hearings before, and parole is so much easier than probation is. Because parole is sort of, in a way, it's sort of like college. And this is the best way I can explain it. When you're in public school and you're not in college yet, everybody is telling you everything to do. This is your class for today. That's what probation does. When you get on parole, what they do is they don't tell you, you need to do this, this, and this. They just give you a sheet of paper. You have your freedom. And on parole, if you report, call them whenever they want you to call and do a drug test and get employment, they're happy. They're satisfied. So for you to have the parole issues that you've had, that tells me a lot. But I'm recommending the therapeutic community for you. The therapeutic community will help you when your parole time comes up, because they're going to see that you are actually doing something to try to help you with your drug addiction. Because when people are looking at whether or not to place you on parole, and I've done parole packets for my clients in the past too, they want to know if they place you on parole, is this a person who's not going to commit any more offenses? So you need to be working on a plan. Like, I'm going to be doing sober support meetings. This is where I'm going to be doing them. This is where I'm going to be living. I'm going to be stable. This is how I'm showing you that I'm going to be stable. That's what you'll need to do for them, okay? All right, good luck to you, sir.
In the end, the court handed Glenn White a 5-year prison sentence, with credit for time served and a concurrent run with his other conviction. Notably, the judge entered affirmative findings for both deadly weapon use and family violence. This ruling carries serious future restrictions, including a lifetime ban on firearm ownership. While the judge did recommend therapeutic community rehab, which may help during parole review, she made it clear, past behavior is the best predictor of future conduct, and White's past speaks volumes. This wasn't just a legal decision, it was a statement about accountability. A man with decades of criminal behavior, who missed chances and burned bridges, finally ran out of second chances. So, what do you think? Was justice served, or was this sentence too harsh for a 62-year-old man claiming to have changed? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'll see you in the next one.